My guest today is Professor Tushnet, who's professor of law at Harvard Law School. Her work currently focuses on copyright, trademark, and false advertising law. She's also an expert on the law of engagement rings. You didn't send me anything on that, Rebecca. So, having grown up in India, I'm very interested in jewelry. So perhaps toward the back end, we can talk a bit about that. Um,
Absolutely.
so I want to start with one of your papers, First Amendment Neglect in Supreme Court Intellectual Property Cases. You say here courts in recent decades have carved out some space for free speech despite the expansion of infringement doctrine by applying judicially created doctrines like transformative use and the Rogers test to stop the expansion at the point where the tension with the First Amendment became too great. The tensions between the court's treatment of profit-seeking speech in IP cases and its treatment of such speech elsewhere may someday, you say, force the court to confront what it has long been able to avoid. The fact that the current bloated trademark and copyright laws cannot, without significant modification, coexist with the non-IP version of the First Amendment. So a good part of our audience, Rebecca, are scientists and technologists and economists, and I'm in that vein. So we want to sort of understand the First Amendment. What are the things it includes? We hear that all the time in popular press and on TV, but it's sort of a summary of First Amendment. What are the things that it's really trying to protect, change, or whatever? Yeah.
Right. So the First Amendment actually covers a number of things. So freedom of expression, freedom of religion, freedom of assembly. So I focus on freedom of expression, and I would say the basic principle is unless the government has a very good reason, it can't punish you because of the content of the things that you say. So there are cases where the content is so harmful that it can punish you for that, but they're very rare and they're limited to situations where we have a societal agreement, not only that these things are harmful, but that they have really no countervailing benefits. So the example that makes the U.S. most distinctive is its treatment of defamation. So if you're a public figure and someone says something bad about you, it's only punishable if it's verifiable and false, and you knew or should have known that it was false when you said it. So actually, one of the interesting things is, if you've seen any of the memes about JD Vance and couches, right? That actually begins with a blatantly false statement that was, as far as anyone knows, intended as a joke. It's sort of easily disprovable that he wrote that in his book. In other countries' systems, that would start out being defamatory. In the US, it could be, but it's not even obviously defamatory. That is, it isn't obvious that like everyone would agree that it's harmful to your character to have engaged in a practice that frankly many young men probably do.
So let me ask you this, Rebecca. So there's a recent case, not a case, but a recent incident where a electric vehicle CEO, electric vehicle manufacturing company CEO, also has a social platform. And the policy of the platform is that they don't let electronically altered content on the platform. But the CEO posted an electronically altered content of a presidential candidate. And his defense was, look, this is just parody. I mean, why are you guys so, taken aback by that? So if somebody posts something and says, look, it's parody, is that good enough?
So the question in U.S. law is basically would people understand that to be parody? And usually, so you definitely can't get out of defamation by saying, in my opinion,
Mhm.
X, did this horrible thing that is defamatory. The words "in my opinion" are not magic. On the other hand, there is a strong argument that it's very hard to believe anything that is said online, especially by certain people. And if that's the case, right? So the U.S. outside of trademark law
Yeah.
generally says saying mean things is not defamatory, right? And so even if what's generated is, an irrational feeling of dislike, as long as there's nothing factually false, it's okay. And there's a case involving a 1980s political figure where a pornographic magazine ran a parody ad. There was an ad campaign by a liquor brand about celebrities talking about their first times, and it was their first times drinking this liquor brand. And so the pornographic magazine did a parody of that and had this guy, the Reverend Jerry Falwell, supposedly talking about how he had had sexual relations with his mother when he was a child, right? And it was not believable. It was extremely offensive, understandably, but given what the magazine was, given the format, there was just no way that a person who was paying attention could have taken it as a serious factual claim. And the Supreme Court said, yeah, that's being offensive is not a sufficient reason to punish anyone for speech under U.S. law. And then the paper that you mentioned is in part about how in trademark courts have not noticed that problem nearly as much. So making fun of a brand might be something you could get sued over, which is what happened to these fellows who made the dog toy that sort of parodied the Jack Daniels bottle. And the risk is, of course, that lots of people have trademark-like interests. So Donald Trump is at least as strong a brand as Jack Daniels. So if you can use trademark law to prevent people from making fun of Jack Daniels, then you can use trademark law to prevent people from making fun of Donald Trump. That's a really bad thing. And in fact, I would argue that you should be able to make fun of Jack Daniels too. That that there's more sort of political necessity to do that with political figures, but that's not enough of a reason to say, you can only do it for political figures. No, Jack Daniels, CVS, the post office, they should all be up for grabs in terms of making fun of them.
Yeah, so as a computer science guy, Rebecca, a lot of things are going through my mind. So suppose my objective is to have some misinformation out there, and I don't want to get sued. And so I'm going to deploy some sort of an AI program, which is a sort of an optimization program, just like this electric vehicle CEO did. And I say the program is going to fine tune the content in such a way that I won't get sued. Okay, so I'm going to put it out there. We have 200 million voters, 100 million of them. Just watch whatever comes to them and say, yeah, this should be true. And if I get sued, then I know I'm going to say, look, it's parody, and I can prove that. So I think we are treading into a very, very difficult time now because it is not very well defined. Parody is not very well defined. I'm not sure if the legal system has a very good handle on this particular question. What's your perspective on that?
So I guess I would say two general things. One is that, sort of fake news, rumors, those have always been part of political culture. And I would say it's not at all obvious to me that countries that have stricter legal regimes do any better in avoiding lies in elections, right?
Okay.
So Britain has notoriously stringent laws and notoriously, let's say, chaotic, democratic politics.
Yeah.
I would say both the U.S. and the U.K. are democracies, right? This is, so they just have the major determinants of whether there's a lot of misinformation don't seem tied to having, a very lax defamation regime. And then the other side of that is the American tradition is very distrustful of the government because our main experience is some level of government, whether that's state or federal or local, deciding that you're the enemy and going after you. And defamation law is a really good way to do that, unless it's really hard to hold someone liable. So the reason that the case that sort of started off the distinctive U.S. approach was the New York Times got sued down in Alabama for running an ad opposing segregation. And an Alabama jury decided that the New York Times was responsible for the ad, that the ad was defamatory to public officials because it suggested that, they had sent, 6 cops and they'd only sent 5, to break this up. Right. So the idea of we don't trust the government not to punish you for tiny little mistakes.
Yeah.
Is, I think, a very powerful one and still quite important because there are governments across the country that are willing to do that.
Yeah, so that's very interesting. So if you sort of parade the countries in a spectrum, what you're suggesting is that if you have very, very stringent laws, it's very unclear if it is really reaching any better position. I don't know if you studied India, Rebecca. So there was a recent situation there that, the prime minister wanted to put the opposition leader in jail because the opposition leader said, this guy is, I don't know, I don't know exactly what he said, something like he is taking bribes or something like that. And so there was a whole spectrum, right, in democratic countries, and the law appears to differ quite a bit across that spectrum, right?
I think that's true, and I think the usual U.S. defense is that we've got it right. That the risks of putting your opponent in jail for things that they say is it's such a temptation if it's available that it should not be available except in the most extreme of circumstances. And I also think there's wider cultural issues, and again, like the law just can't determine all of that. But I tend to feel like we've earned our distrust in the U.S. And also we have so many different levels of government that it's. There's always somebody who's tempted to abuse their power. And so, I think it's probably better on balance for it to be very hard for them to do so.
Yeah, it's satisfying, in the sense that with all the push and pull that happens in the spectrum, we are not necessarily really badly off, is what I'm hearing.
Well, so we're certainly not problem free. On the other hand, the other kind of big defense of the American system, I think, is in the system that we have, where the default is you get to say what you want, and somebody has to prove that it's harmful before they can stop you, and harmful in a way that the law recognizes, not just insulting. Is if you look at our kind of news reporting industry, if you look at our tech industry, right? So we dominate the world, for better or for worse, because that freedom does produce a variety of things, some of which are really, really successful. So, I mean, it is, I think it's uncontroversial that there's no way you get Google or Microsoft or Facebook in other countries, and for good and for ill, right?
Hmm.
And I think a lot of times people really hope that they can get only the good parts of Google or Facebook and none of the bad. And that's just, as long as people are using them, that
Yeah.
won't happen.
So is it a sort of two-step process, Rebecca? So I have heard like cease and desist. So suppose I find somebody doing bad, saying bad things about me or doing bad things to me. I send them some sort of cease and desist before I go out and have a full-fledged lawsuit, right? Is that the way it's done, or?
Yeah. So, and this is actually another way in which the systems are probably more similar than different. If you're a normal person, getting a letter from a lawyer is, it's just unpleasant, right? Regardless of the underlying merits. So, it definitely does get you to think twice. And again, sometimes that can be a really good thing, and sometimes that can be suppressing speech that is legitimate. So, um, it, I, obviously, I think it's good in most cases to try and resolve problems
Yeah,
without litigation.
yeah.
Um, and the question is sort of what are the strength of the tools that people have,
Hmm.
and how subject to those are those tools to misuse. And this is again something, copyright and trademark, because they people conceive of them as sort of intellectual property rights. They're
Yeah.
really, really good when they're misused to shut down speech, right? They're really powerful because they don't sound like I'm insulted and I just don't want to hear this,
Hmm.
even if that's the motive for using them.
So you say here, I want to understand this a little bit more, Rebecca. So profit-seeking speech in IP cases
Mm.
and its treatment. Um, so profit-seeking speech. I filed for a few patents. Some of them are not published, let's say. And in this podcast, if I talk about one of my patents that's not published, is that profit-seeking speech?
So it's a great question. And the interesting thing is that intellectual property law tends to have one answer and First Amendment law would have another. So the First Amendment has this category called commercial speech. And this is very, very much under threat, but for 50 years, the rule has been if you are selling something, right?
Hmm.
If the speech is promoting a separate product or service, that's
Yeah.
commercial speech, and we can regulate it at least for falsity, like without worrying about much more, right? And we can also sometimes make you disclose stuff that is
For
relevant.
societal good, for societal good
Right,
in some sense, right? Yeah. Yeah.
exactly. Whereas the New York Times is trying to make money, but
Yeah.
I mean, they like to pay their reporters. The reporters like to get paid, right?
Yes.
Hollywood is trying to make money, right? TikTok creators who do dances are trying to make money, but they're not advertising a separate product, right? So when the
Hmm.
New York Times says you should subscribe, they are advertising themselves, and then of course they may run advertising, but that's a specific part
Hmm.
of what they do, and you can't just ban false or misleading, non-advertising speech. You have to show that it has a recognized harm, like defamation. And it's the idea of protecting someone in a transaction, right?
Yeah.
So the New York Times says to advertisers, we reach 15 million people. Okay, that's actually commercial speech. If they're not telling the truth about that, then there's a specific problem. But if they're reporting about, the Olympics is wrong,
Hmm.
that's not advertising. That's just they have some bad content.
Right.
And so that's the idea, that for wanting to make a profit outside of intellectual property law doesn't mean your speech is commercial. It means
Yeah.
that you're participating in the economy.
Yeah. So if I understand this correctly, Rebecca, so if commerce is attached to speech, it's in one bucket. If commerce is not attached to speech, it's in another bucket. Is that the way to?
Well, so yeah, I hate to be a lawyer about it, but it depends on what you mean by commerce, right?
Yeah.
So I think the Deadpool and Wolverine is, it's commercial in the ordinary sense. They would like to make a lot of money. They are making a lot of money, but
Yeah.
it's not advertising. So advertising is maybe a good shorthand
Hmm.
for the kinds of things that should be easier to regulate because you're protecting someone in a transaction, right?
Hmm.
So, if someone advertised Wolverine and Deadpool and you show up and they show 9.5 weeks instead, you got grounds for complaint. But if
Hmm.
the movie is bad, you don't.
Yeah, so this is a really interesting problem. So the conflict is between freedom of expression. So one end of the spectrum, we could have no constraint. And the other end of the spectrum, we could have a highly constrained position. And if I understand this correctly from you, Rebecca, UK is sort of on the other end of this.
Yes.
And so this is a very interesting thing. So that, from a mathematical sense, the optimum might be in one end or the other, because in the middle, I think you're going to get. I'm just speculating here. I haven't really done analysis. In the middle, you're going to get suboptimal outcomes. So it's almost like you sort of gravitate toward one end or the other.
So, I'm not sure that's true. And of course, the spectrum, there's lots of other places on the spectrum, right? So China has a completely different relation. And of course, it's not a democracy, right?
Yeah.
So, uh, I tend to think that democracy ought to be the primary value. And then, freedom of expression is one way to keep that value in place, and a very important way, because if people are not free to talk about what's going on politically, then there's huge problems, and you can't respond to what's going on in society. So we're definitely seeing that in various places around the world.
So I'm sort of confused about the Supreme Court. So they seem to make a lot of judgments, and they say this is our interpretation of the law.
Mhm.
But they pretend to be physicists, like general theory of relativity or Newtonian mechanics. But it is a group of people saying this is how we feel based on what we know. And so is the Supreme Court um, sort of making this where it should be? Because precedent, I don't know
Mhm.
exactly how it works, but what I'm asking is Supreme Court a function of where the law is?
It's
Or yeah.
Yeah, it's a great question, and let me just say something that I say a lot, which is um, Trump and Biden appointed a third of the federal judges that exist now, right?
Yeah.
That's really a lot, and Trump did more and more impactfully, because he had 3 Supreme Court slots to fill. So it's not surprising that U.S. law is going through some pretty big upheavals right now.
Hmm.
I would say law is both political, and when it's done right, it has some distinctions from politics. So it shouldn't just be, which political party does this favor, but it is also clear that how where you sit influences how you think and what you think are plausible arguments. So I would say there's a lot of ferment going on, and it's also true that along with the First Amendment, the judicial review, where courts in the U.S. can actually strike down laws, that's
Hmm.
also very unusual in democracies.
Oh, wow.
Um,
Okay. Yeah.
yeah, most other democracies have at least room for back and forth, where if the legislature passes something, and the court strikes it down, the legislature can come back and try again.
Hmm.
And there are various ways you could do this. The kind of good idea behind this is when something really is disruptive of kind of core rights that we've previously agreed on,
Hmm.
you should at least have to make sure that it's 2 rounds of voting go into making that change, right? So if if in 2020 the Congress passes something and the court says, wait a second, this doesn't seem consistent with our tradition of rights. If in 2024 a different Congress passes it, that's some evidence that in fact that's where the people are now. That is not the U.S. system, right? The U.S. system is the Supreme Court sits on the top and says yes or no, and that's probably much less worth emulating. Like I actually I'm a big defender of the U.S. approach to free speech, not so much the U.S. approach to judicial review.
Yeah, I think I don't know much about this, Rebecca, but I think the Indian system is closer to the U.S. system, even though it's based on the UK sort of principles. Because the Supreme Court appears to have a lot of power there,
Yeah,
just like our Supreme Court. Yeah.
Yeah, so I don't know a ton about the system, but I do know there were things like the Aadhaar, the ID card, which is really interesting and poses and has both huge risks and huge benefits, right? For people, and I would say it's probably good to have multiple branches of government taking a really close look. But I do note, so what they did is they went back to the drawing board, right? And they made some changes in response to what the Indian Supreme Court said. And then the current version of Aadhaar is what you ended up with. And so that kind of back and forth is just not as common in the US system, almost certainly to our detriment.
Right. Okay. So we don't have a lot of flexibility, it feels like. And so I want to go into another paper. It says, of Bass notes and base rates, avoiding mistaken inferences about copying. You say here in fragmentary copying cases, plaintiffs claim that they created their works ex nihilo without copying the expression at issue. They also claim that the defendants did not do the same. So plaintiffs' experts often translate infringement claims into arguments that the similarities between the works are such that the independent creation is unlikely or essentially impossible. So again, from a mathematical perspective, this is a statistical question, as you say in the paper. And I'm not sure if judges are statistically trained. And so this is a problem, right, in many ways?
Yeah, so once you decide to have generalist judges, then it becomes very important what their sources of information are. And actually, this paper, one of the genesis of it was that many years ago when I was in practice, I worked on a case where there was precisely this problem. So the plaintiff had a model that said, it's 99% likely that these two drug names will be confused and they'll cause medication errors. And if you looked at the numbers, right, so basically it came from a relatively small set of training data, a database of drugs that had been actually been confused in practice. And it was like, 150 of them.
This is Pharmacia? Pharmacia is the
Yes. And so if you looked at the model, so they had this tiny training data set, and then of course this huge universe of potential drug pairs, right? Because it's just, it's just whatever the number of drugs on is available, factorial is the universe of possible pairs, right? Yeah. And although 99% sounds really good, once you introduce even like a 1% error rate, you get this problem, which is if something is predicted to be likely to be confusing, you're more likely to be wrong than you are to be right in your prediction. Even though you have a very sensitive test, when you're looking for a very rare condition, right? Your test is a positive result on your test does not mean that it's more likely than not that the result is positive. It means you need to inquire further. Right. And in that case, we hired a math professor to actually teach the judge the sort of Bayesian statistics required. And it worked really well, which was good. Although I will tell you another anecdote, which is, anecdotes do better than data. So although I thought we did really well with the math professor, what really killed the other side's model was at oral argument, or at they had their expert testifying, and the question was, okay, using your mathematical model, is it likely that the words Mexican and American will be confused? Because they share a lot of letters, in fact, and that was the basis of claiming similarity. And the expert said, oh yes, they'll definitely be confused. And at that point, the judge was like, well, I don't believe you. Because Mexican and American are very different words.
So in pharmaceuticals, I have a solution for this. And that is, don't have a commercial name. Just use the original chemical name. The doctors will hate it because it'll be long names, but there'll be no confusion.
So exactly. I suspect you'd have some confusion there because people would sort of forget, which ester this is, right? Or whatever the like dilufimab, right? Like memory would give you problems even if there weren't any conflict.
Yeah, that's true. So you talk about music
Yes.
also in the paper, and music is really interesting. So yeah, I mean, I can't even begin to imagine how you can approach this problem. It's so complex, right? So what are your thoughts? Yeah.
So the underlying problem actually is that copyright has gotten way too bloated. So in the ordinary case, right, if it turned out that, in this conversation, I used, 5 words in a row, and, in some other conversation, somebody else used the same 5 words in a row, you would never think, oh, there's a copyright infringement there, right? But in music, 5 notes can definitely get you sued. And in fact, there's a line that people in music use where there's a hit, there's a writ. So if you have a hit song, someone will show up claiming that you copied something. And it would be one thing if they were claiming, here's, a full verse and, they're the same. But no, today's cases are overwhelmingly in music about, well, here's this sequence of 6 notes, or even worse, here's the sequence of 6 tones arranged in the same way as your arrangement, even though they're different notes. Like an expert can tell you they're actually the same. And so once you do that, you're in the world of pharmacia, where there are so many possibilities that just having an overlap does not indicate anything about the likelihood of copying, right? And of course, the point that we were trying to make was, the plaintiff says, I was sitting here and out of nowhere, I imagined these 6 notes. And but it's just impossible to imagine that anyone else could have been sitting down and the same 6 notes would have come to them. And that story doesn't make a lot of sense in the abstract, especially when you're suing somebody who, frankly, is likely to be a better composer, right?
Yeah.
So, if you're suing Taylor Swift, she's, she's pretty good at coming up with music, and even without copying it. And the fact that you both hit on the same sequence says nothing, right? If it were a whole verse, you might think differently about it. But if we're allowing these little fragments to be something you can litigate over, we have to recognize that, in fact, it's super likely that there will be a bunch of overlapping little fragments without copy.
Yeah. So let me ask you a sort of a loaded question, Rebecca. So we have this AI thing going on. AI is fundamentally using all sorts of historical data. I don't know what all it's ingesting. Books, proprietary books, proprietary research, proprietary music, I'm pretty sure. and it's going to regurgitate out something. So we have this generative AI concept, right? So it can sort of mix and match things and put something out that sounds interesting. So are we sitting on top of some sort of volcano here that in
Yeah,
terms of legal issue as we
right.
look forward? Yeah.
Right. So lots of people are interested in this question. And I would say um, this is another effect of the fact that copyright law is much stronger than many other forms of law. So, when all you have is a hammer, everything looks like a nail.
Yeah.
So people are worried about AI and they say, oh, we'll use copyright. And I, I don't think that copyright is the big problem with AI,
Hmm.
right? I think, job displacement, whether it's hallucinating things, those are real issues and probably do deserve some regulatory response. But in many ways, the idea of like regurgitating is, think about how you learned stuff and how I learned stuff, right? Somebody put existing things in front of you
Yeah.
and you mastered them, and you can, in some sense, you're like putting out, your own combination,
Yeah.
and that's okay, right? That's
Right.
what we
Right.
want learning to be. Now, there is a difference. The machine is not conscious, but the basic idea of taking in information and then using it to generate something new is totally fine, and generally what we want from
Yeah.
a society that is building on existing things. So existing knowledge, existing creativity. Um, a big question is it actually generating things that are sufficiently different from what's gone before? Because, if it's constantly spitting out,
Yeah.
a near exact copy, that's a very different issue than if it is, spitting out something that in fact is different from things that have gone before, even if it has, weird six fingers.
Yeah. Yeah. This is really interesting. So the novelty is an important concept. So suppose I have an AI program that is, basically sort of combining existing things
Mhm.
and writing something that sounds better, quote unquote, let's say. Um, is that copyright protected? So clearly, if I come up with something novel,
Mhm.
something new completely, that is a different question, right? So I don't know where Harvard is on this. A lot of the universities have stopped reading essays, of students for admissions because they're all written by AI anymore. Um,
So yeah,
yeah,
I have so many thoughts about this. Where to start? So I will say, at the top end, uh, there's there's no way that AI could compete with a good writer. Uh,
Hmm.
uh, uh, it's just because the whole point of AI is that all the edges are rubbed off, and the edges are what make people interesting as writers. So, the AI would never produce the stories that make me stop and say, "Oh my God, I really want this person to attend our school.
Hmm.
They seem really interesting." Um,
Yes.
so that's and uh, I so I do think there are definitely educational challenges,
Yeah.
but I again, plagiarism and did you do your own work are just very different questions from copyright infringement,
Yeah. Yeah.
because what I'm interested in is, can the student produce their own analysis,
Hmm.
right? And it doesn't actually matter if a student put together an essay answer that was almost entirely quotes from court opinions, right? Not their own work, but they actually put it in an order that indicated they understood
Hmm.
what the relevance was, right? I would say that's a great answer, right? Because the purpose for which you make an argument about court cases, right? You don't want to be making stuff up. You don't,
Hmm.
innovation is the opposite of what we want. We want
Yeah.
you
Yeah.
to answer within the confines, just like we want you to get the right answer on the math problem. right? And even if there's no right answer, we want you to give a reasonable answer given the field of knowledge you're working in. So, copyright just is a really cramped and not very useful way of thinking about it. Because I want people who know how to give me a relevant answer, and that can involve a bunch of copying.
Yeah, that's really so. I mean, it's funny that you say that, AI cannot replicate a good writer. I had a recent experience on, the social platform LinkedIn. When you write a message or when you write, some sort of a post or something, it has a little button at the bottom of that. It says "Write with AI," and I clicked it one time. It completely wiped out what I wrote and wrote something else. I was completely dissatisfied with what AI wrote, and I couldn't get my original text back. I had to basically rewrite the whole thing. So there's a problem there in some sense, right? It's clearly not replicating your personality. It's clearly not replicating what your thoughts are. It is potentially grammatically more correct, but it's I don't know if that is interesting actually. Many times, yeah.
Right. Right. If no human wrote it, why would a human want to read it? Basically.
Yes. Yes. So I want to finish up with one of your other papers. It depends on what the meaning of false is. Falsity and misleadingness in commercial speech doctrine. So we talked a little bit about this, but we can expand on this. So here you say the Supreme Court's commercial speech doctrine is much debated, largely with a focus on the level of protection the doctrine allows for fruitful, non-misleading commercial speech. Some, including some on the Supreme Court, attack the distinction between commercial and non-commercial speech as theoretically unjustified and practically unmanageable. Less often targeted by academic commentary is that the governing law excludes false or misleading commercial speech from any First Amendment protection whatsoever. This relative lack of attention has obscured the practical difficulties that abolishing the commercial speech doctrine would pose. So this almost sounds like we need a change in the law in some ways.
So what I would say is, and I think that's a slightly older piece, and some of this I think is becoming more apparent. It turns out to matter a lot who has the power to say what is false, and it's easiest to see with kind of hot button issues. So consider abortion, right? If it can a legislature vote and decide abortion increases the risk of breast cancer, right? Can they find that as a fact? And if they find that as a fact, can they make people who provide abortions tell that to you, even if their own reading of the data is no, that's not true at all, right? Is gender affirming care, the good for young people, right? Does it decrease the number of suicide attempts, right? So is it false or misleading to say, I can give you gender conversion therapy so that you won't be distressed about the body that you were assigned at birth, right? I can fix you, right? Or I can convert you from gay to straight. And so there are a whole bunch of questions that turn out to be actually quite political that are framed as matters of fact. So, is trans fat bad for you, right? That's no longer controversial, but there's a whole bunch of controversy about it in the past. What about vaccines, right? So the power to decide what is false is a really important one. And that's sort of and the example I use in the article is actually the definition of organic, which turns out to involve a whole lot of trade-offs, because if you want people to buy organic, you actually have to be a little loose about the standards, because there's some stuff you just can't get to be organic, right? like there's like one plantation in Madagascar where all the organic vanilla comes from, and if there's a storm, then there's
Mm.
no organic vanilla. Does everybody have to take all, like, even if they're using organic sugar, organic milk, right? Do we not get to have organic vanilla ice cream anymore?
Mm.
If or do we write the regulation to say you can call it organic if 95% of it is organic?
Yeah, so there's a larger question here, Rebecca. So I want to get your perspective on this. So as science and technology advance, um, policy becomes very complicated. Um, Politicians clearly don't have the competence. Um, and so how do you make the last energy secretary that I know who was competent, let me make a grand statement, was Professor Chu from Stanford, Obama's energy secretary. Energy is such a complex policy question. And how can somebody without a technical training, a lot of information and knowledge make policy? And the abortion question is sort of a similar question. Uh, and so politicians and policymakers appear to think that they got it. But this is a big slippery slope, I think. I mean, it's going to get worse as we go forward.
Right. And I do think this comes back to trust, right? So one of the reasons we have freedom of speech is so we can get people telling us that we're wrong and need to, make political changes. So I guess what I would say is that I absolutely agree that a lot of these things, it's very hard to become competent to say something about it. And I think there's no comfortable endpoint,
Hmm.
because at the same time, the people should have the right to decide what they prioritize
Hmm.
in terms of their politics. And if they prioritize uh, well, if they prioritize destroying the planet, maybe
Yeah,
that's
I
what they've
mean, yeah, you could go in the other direction and say, policy is largely about science and technology. It's not about politicians or politics. Um, in which case, it'd be a different society, obviously. I don't think we're ever going to get there. But you need a lot of technical information to make optimum policy, right?
done.
It's not a political question.
So I would say, I think we have the general outlines in something like the FDA, which is, the policymakers make the goals, right?
Yeah.
So, we would like to, cure more cancer, right?
Yes.
Have more vaccines, and then, okay, you guys go evaluate whether this is a good cure for cancer or cancer treatment, right? And the thing that's frustrating to people who want like a permanent solution is there's never a permanent solution, right? You're always deciding, well, is this safe and effective given the other things that are available? And you might approve something, 1 year, and then 20 years later, something that's so much safer comes that you say, this isn't safe and effective anymore, right? Now
Yeah.
that we have these alternatives.
Yeah. Specific questions, I can see FDA and NIH have a good system, but broader societal questions like the climate change
Mm,
and things like that, we don't really have an agency. I don't know. I'm just speculating.
right.
Like FDA or NIH on that one.
So, I guess what I come down to is uh, the kind of Winston Churchill line, that this messy democracy is far from perfect, but everything else that people have tried has been worse.
Yes.
Right? So uh, uh, that's neither an absence of government nor government controlling everything have been notably successful. So in fact, it's in the contestation, the continued fighting, and the continued willingness to kind of revise what we thought before, that I think is our only hope.
Yeah, so I know that you have to go. Winston Churchill also said Americans will try everything till they find
Americans
out
can
what's the right thing to do.
They can always be
And
relied to do the right thing after trying everything else first. Yes.
so hopefully in November we'll find what the right thing to do, hopefully. Excellent, Rebecca. Yeah, thanks so much for spending time with me.
Well, thank you for having me.
Thank you.